One satisfying IRS letter in 2026 could cost you your green card, your citizenship application, or thousands of dollars in penalties. And the terrifying part is, you might be triggering it right now without knowing. If you are over 60, a green card holder, a naturalized U.S. citizen, or an immigrant who files taxes in the United States, there is a new IRS filing rule taking effect in 2026 that you need to know about now, not later, because this change can quietly trigger penalties, audits, and for some immigrants, serious problems during immigration reviews, even if you believe you've done nothing wrong. Here's the dangerous part. Most people affected by this rule think it doesn't apply to them. They file taxes every year. They report U.S. income. They trust their tax preparer. But starting in 2026, the IRS isn't just looking at what you file. It's comparing your answers automatically across systems. If something doesn't match, the flag happens instantly. And I know what you're thinking. Taxes are already stressful. For seniors, they're confusing. For immigrants, they're personal. Because tax records don't stay with the IRS. They follow you into citizenship applications, green card renewals, and benefit decisions. This video is not about fear. It's about preparation, because this rule is coming. And once you understand it, you can stay fully protected. Stay with me until the end, because one small detail most people overlook is exactly what triggers penalties and delays. Once you see it, you'll understand why this rule matters so much. So let's talk about what actually changed and why this rule exists in the first place. Starting with the 2026 tax year, which means tax returns filed in early 2027. The IRS is rolling out a finalized filing rule that fundamentally changes how certain taxpayers answer questions on their regular tax return. This rule did not appear overnight. It was proposed quietly, refined over time, and is now locked in. At the core of this change is one simple idea. The IRS wants answers directly on your main tax return, not buried in separate forms that many people never realize apply to them. For years, reporting foreign bank accounts, foreign pensions, or overseas assets often depended on whether you knew about special forms, thresholds, or technical definitions. Many people didn't. The IRS knows that, and instead of assuming everyone will discover those forms on their own, they are now forcing the conversation onto the front page of your tax filing. Beginning in 2026, seniors age 60 and older, and anyone who is not a U.S. citizen by birth, will be required to answer expanded mandatory questions on Form 1040 itself. These questions will ask directly about foreign financial accounts, foreign retirement plans, foreign government benefits, and international money movement. These are no longer optional disclosures. They are no longer tucked away in instructions. You will see them, and you must answer them. At the same time, the IRS has lowered the reporting thresholds for foreign financial assets for these groups. Under the old system, many taxpayers stayed below the reporting line and never had to file additional paperwork. Under the new rule, that line is much lower. Assets that once seemed too small to matter now cross the reporting threshold. And when those thresholds are crossed, additional forms become mandatory, not optional. Here's the key shift most people miss. The IRS is no longer treating each form as a separate island. Your answers on the main tax return will now be automatically compared against other filings in government databases. If one answer suggests you have foreign accounts, but another required form is missing, the system notices immediately. No human review is needed to start the process. The trigger is automatic. This rule is part of a broader push by the government to improve data matching and compliance, especially in areas where mistakes are common, but enforcement has historically been inconsistent. Seniors and immigrants, according to the IRS, represent the largest group of taxpayers who unintentionally get foreign reporting wrong, not because they are hiding money, but because the rules were never clearly placed in front of them. That is why this change feels sudden, even though it has been years in the making. And it's also why understanding how this rule works before it takes effect matters more than fixing mistakes afterward. Now, let's break down exactly who this rule affects, because this is where a lot of confusion starts. The IRS is not applying this change to a small, narrow group. It reaches across several categories of taxpayers, and many people fall into more than one without realizing it. First, seniors who are U.S. citizens. If you are 60 years or older and you have any financial connection outside the United States, this rule applies to you. That includes foreign bank accounts you kept from earlier in life, retirement or pension payments from another country, small savings accounts you use when visiting family, or even accounts that sit mostly untouched. Under the new system, you will be required to disclose these directly on your main tax return, even if the amounts seem modest and even if they have existed for years without issue. Next are green card holders. For permanent residents, the impact is deeper than just taxes. The U.S. treats green card holders as U.S. tax residents, which means worldwide income reporting has always been required. What changes now is visibility. Your answers on your tax return will be cross-checked more aggressively, and discrepancies can be flagged and shared across agencies. This does not mean an automatic denial of citizenship or immigration benefits, but it does mean additional scrutiny. Questions that once came up only if something looked unusual may now appear routinely during naturalization or other immigration reviews. Then, there are naturalized U.S. citizens. Even though you are a citizen, this rule still applies because you are not a citizen by birth. The IRS has made it clear that the intent is not to single people out unfairly, but to recognize a statistical reality. Naturalized citizens are more likely to maintain legitimate financial ties to other countries. That reality now translates into mandatory disclosure questions that must be answered accurately every year. Visa holders are also included if they meet U.S. tax residency requirements. This affects people on work visas, long-term assignments, and certain treaty-based residents who file U.S. tax returns. If you fall into this category and have financial accounts or assets outside the United States, failing to report them correctly could follow you beyond tax season and into future visa renewals or green card applications. The important thing to understand is that this rule does not care about intent. It does not ask whether you meant to hide anything. It only looks at whether your answers match the records the government already has access to. Many people who get flagged under this system are fully compliant in spirit, but incomplete on paper. And that's why this section matters. Once you know you're affected, the next question becomes what the real risks are if something is missed, and how serious those consequences can be. This is where the consequences become very real, and why this rule deserves your full attention. When the IRS designed this change, it wasn't just about collecting information, it was about enforcement. And under the new system, enforcement no longer waits for a human reviewer to notice a problem. It starts the moment the numbers or answers don't line up. If required information is missing or inconsistent, the IRS can automatically generate notices, penalties, or audit referrals. One of the most common triggers is when a taxpayer acknowledges having foreign accounts or assets on their main tax return, but the supporting forms are missing or incomplete. Another trigger happens when government databases already show foreign financial activity, but the tax return does not reflect it clearly. These mismatches are no longer ignored or delayed. They are flagged immediately. The financial penalties alone can be severe. Failure to properly report foreign accounts or assets can result in thousands of dollars in fines, even when the mistake was unintentional. Some penalties apply per account and per year. Others increase if the IRS believes the issue was not corrected after notice. And once penalties start, interest continues to accrue until the issue is resolved. But for immigrants, the risk goes beyond money. Tax compliance is closely tied to immigration credibility. If your tax filings show inconsistencies, missing disclosures, or late corrections, that information can surface during citizenship interviews, green card renewals, or benefit applications. Officers may ask why something was not reported, whether the omission was intentional, and how it was corrected. Even when the outcome is ultimately positive, the process can be delayed for months and become far more stressful than it needed to be. I have seen situations where applicants were fully eligible, had clean records, and still faced long delays simply because their tax filings didn't match perfectly across systems. What used to be considered a minor oversight now becomes a formal issue that must be explained, documented, and resolved. And here's the part many people underestimate. Fixing problems after the fact is almost always harder than getting it right the first time. Once the IRS initiates contact, your options narrow, deadlines shorten, penalties stack, and if immigration benefits are involved, timing becomes critical. That's why the smartest move is preparation. Understanding the rule before it takes effect gives you time. Time to gather records, review past filings, and correct issues calmly instead of under pressure. In the final part of the video, I'm going to walk you through exactly what you should be doing now, not later, to protect yourself, your finances, and your future. So what should you do now, before this rule takes effect and before the pressure starts? The goal is not perfection. The goal is clarity, consistency, and preparation. And there are a few practical steps that can make an enormous difference if you take them early. Start by gathering information about any financial connection you have outside the United States. That includes bank accounts, retirement or pension plans, government benefits, investments, life insurance with cash value, real estate interests, or ownership in foreign businesses. Even accounts that are rarely used or currently inactive matter. What's important is knowing what exists, where it's located, and the highest value it reached during the year. Next, make sure you understand whether you are required to file separate foreign account disclosures. Many people confuse these filings or assume their tax return alone is enough. Under the new system, the IRS will compare your answers across forms automatically. If something should be filed and isn't, the system will notice. If you are unsure, this is where a qualified tax professional can help you determine what applies to your situation and whether any past gaps should be addressed proactively. If you receive pension payments or social insurance benefits from another country, review how those are reported on your U.S. tax return. In many cases, tax treaties may reduce or eliminate double taxation, but the income often still must be disclosed. Reporting correctly protects you, even when the tax owed ends up being minimal or zero. For green card holders and those planning to apply for citizenship, documentation is especially important. Keep copies of your tax returns and any related disclosures in one secure place. Immigration officers may ask for them years later. Being organized can turn a stressful interview into a straightforward one. And finally, remember this: the purpose of this rule is not to punish people who are trying to follow the law. It is meant to close gaps that caused confusion for years. If you act now, you stay in control. If you wait until the IRS contacts you, the process becomes reactive instead of proactive. If this video helped you understand the new IRS filing rule for seniors and immigrants in 2026, take a moment to like it and share it with someone who might be affected. And if you want clear, calm updates on tax and immigration changes that matter to your life in the United States, make sure you are subscribed to US Policy Brief and notifications are turned on. As always, everything shared here is for general informational purposes only, and not legal or tax advice. Laws and policies can change, and individual situations are different. Always consult a qualified tax professional or immigration attorney for guidance, and verify details through official government sources. My name is Fernando. This is US Policy Brief. Stay informed, stay prepared, and I'll see you in the next one.